Hi, and welcome to this recording of our professional development session on court interpreting and the recommended national standards. We have a lovely little lineup on screen. We have Ludmilla Stern, and we've got Lavinia Heffernan, and my name's Lauren. I'm part of the NAATI team that works with Indigenous languages. And we're coming to you today from Bunurong country, where I am, and all over the place. So I'll handball to Ludmilla. Would you mind introducing yourself, Ludmilla?
Thank you, Lauren. My name is Ludmilla Stern, and I'm very pleased to talk to you today from Gadigal land in Sydney. I am an academic at New South Wales University, Sydney, having worked as an interpreter, as a Russian interpreter for many years. Nowadays, I train students in interpreting, and I also conduct research in court interpreting. I'm particularly interested right now in the responsibilities and the role of those who work with interpreters, judges, magistrates, and lawyers.
Great. Thanks, Ludmilla, for joining us and collaborating on this. And Anya, would you like to introduce yourself?
Yep. So my name is Lavinia, but my family and friends call me Anya. And I am a Lurich Pindabi woman from Central Australia, a place called Popanya, which is 3 hours northwest of Alice Springs. I'm also part of the NAATI team as part of the interpreting Indigenous project team with NAATI. And I also do interpreting as well. So a CPI certified in the Lurich Pindabi language.
Thanks, Anya.
And I'm on Yugambeh country in Brisbane or south of Brisbane.
Great. So we've got a bit of a spread today. We did run this as a live session in October with a great group of interpreters, experienced as well as new interpreters. And this is a recorded version for people who wanted to watch it in their own time, come back to it, because we think it's a really valuable resource for interpreters to have access to. We also would encourage you to watch it with other interpreters, so you can press pause and discuss your experiences. And there's also a handout that's downloadable with some discussion scenarios that we'll go into later. Okay. Now, NAATI are helping provide these PD sessions as a way for people to be able to improve their skills and knowledge, and to be able to share with other interpreters and stay connected with the profession. But of course, professional development is one of the principles of the AUSIT Code of Ethics. So we're wanting to really encourage people and make sure there are accessible options. And also, NAATI does require certified interpreters to do professional development to recertify. So that's part of why we're making these sessions available. Okay. Now over to you, Anya. Would you like to introduce this topic?
Yeah, so we're doing court interpreting and the recommendation of national standards. Also, we're going to probably call it RNS throughout the workshop. So we chose this topic because we know that a lot of Aboriginal and Torres Strait Islander interpreters are needed to work in courts. And we know that courts are challenging places to interpret in. So many of our interpreters are walking in blind into courts. Not enough training is available for our Aboriginal and Torres Strait Islander people in this area. And it helps if you have a clear understanding of your rights and responsibilities and a chance to learn about it, to work collaboratively with each other's knowledge and experience in a culturally safe way. At some of the language and law conferences that have been held in the Northern Territory, even judges have been exposed to how challenging court dynamics can be. This video here, we highly recommend that you have an opportunity to watch it in your own time. And it's a reverse role of judges, being the people that are being questioned by our Indigenous brothers and sisters throughout the workshop.
Yeah, they get a chance to see what it's like when court proceedings are happening in a language that's not your first language.
That's right. Make them feel uncomfortable.
Yeah. Always fun to watch a judge squirm.
Yeah.
Okay. So as part of today's session, we thought it'd be great if people have a chance to do a bit of personal reflection, if you have worked in courts, or even if you just have ideas about what it's like to work as an interpreter in courts. So if you'd like to press pause on this recording and have a think about what you think your responsibilities are as a court interpreter, what the main principles of the AUSIT Code of Ethics are that apply to court interpreting, and have a think about what rights you think you have as an interpreter, what you can expect from others in court. We had a great brainstorm in our live session with input from really experienced interpreters as well as new people. So hit pause and have a think.
So what are we doing today? We're going to learn about what the RNS says about responsibilities of interpreters, judges, courts, and lawyers, and the interpreter's rights. We encourage you to reflect on experiences and discuss court interpreting with other interpreters, share tricky court interpreting scenarios and discuss them, share resources for learning and practicing legal interpreting. At the end of the session, we hope that you will know what is expected of you in court, know what to expect of others at court, know about resources to continue your own development as a court interpreter. And to talk about the recommended national standard for working with interpreters in courts and tribunals, I'm going to hand it over to Ludmila.
Thank you, Lauren.
Lavinia.
Oh,
but I'm the PowerPoint lady.
Yeah.
Too many L's, the three L's.
So let's talk a little bit about the recommended national standards for working with interpreters in courts and tribunals. Well, first of all, what is the RNS? What are the standards? I would describe them as a set of guidelines, very comprehensive, very detailed guidelines on how to create the optimum conditions for working with interpreters in courts and tribunals. So, as I said, they are the guidelines that aspire to create the most favorable conditions when an interpreter is present in court. And this is why this document has been developed. It was developed, by the way, by a group of professionals that included several judges, the representatives of NATI, AUSIT, and some of my academic colleagues. And in other words, this document represents different perspectives on what are the rights and responsibilities of interpreters, but also the responsibilities of other participants in courts, such as judicial officers, magistrates and judges, and the lawyers. Now, you can say, how different are the standards when compared to the AUSIT Code of Ethics? As you probably know, the AUSIT Code of Ethics tells us about the interpreting profession in different settings, not only in courts, but health and other community settings. And as you probably know, it's mostly about professional responsibilities of interpreters, the responsibility to interpret accurately in an impartial way to maintain confidentiality. The difference is that the recommended standards talk also about the responsibility of other court participants, specifically in the setting of courts and tribunals. And as we will discuss throughout this seminar, is the recommended national standards aspire to make working conditions for interpreters better. And so we are about to look at how they are trying to achieve that.
So, Ludmila, you talk a lot about them being recommended, right? I think
Yes.
that's kind of an important word.
That's right. They are recommended. They are not mandated. And we can say from today's perspective that it's an aspiration, it's a hope that different participants are going to follow them, that they will learn about them and they will follow them. But also we hope that these recommended standards will help court interpreters to feel empowered, even if they are familiar with the responsibilities of the other parties, and if they are able to quote these responsibilities in court when they need something. Again, we are about to look at the standards and some examples of how they are applied. So as you can see here on this slide, there are 4 groups, there are 4 sections in the recommended standards, and they cover the responsibilities, some different responsibilities, some responsibilities that overlap among these 4 groups. Well, the first group is represented by the courts and tribunals and the staff, the administration of the courts and tribunals. The other group are judicial officers, judges and magistrates. The third are the lawyers, legal practitioners. And the fourth are court interpreters. So if we look at the responsibilities of the court staff, of those who work in the courts and tribunals, first of all, the standards make an emphasis on the need to train the staff in the assessment of the need for interpreters to be working interpreters and on working with interpreters. In other words, the emphasis is on the court staff, and the judicial officers being trained. So they have to assess whether there is a need for an interpreter. And they also have to be trained in how to work with interpreters. And we will return to this point a little bit later on. Now, the staff in courts have to be familiar with the role of interpreters as the officer of the court. So the staff have to understand what the professional role of the interpreters is. But they also have to understand that the interpreters do not have the same loyalty to a party or a witness or a defendant as the lawyers have, for example. They are impartial and they are independent, and they owe their duty of their professional duty to the court. And this is why they are described as the officer of the court, irrespective of whether they are full-time employees of a service or whether they are casual or freelance interpreters. So they are unbiased and they owe their duty to the court. And this is why they are described as the officer of the court. Now, other standards address the question of how an interpreter should be engaged by the court. And this is if the court employs the interpreter as opposed to, let's say, the prosecution. And that's a standard number 6. So the courts have to ensure that the interpreter is appropriate, that they speak the right language, that they have some credentials if possible. And also, they have to take into account any cultural concerns and other concerns that might be relevant to a particular language or a particular culture.
It's interesting that you say that, Ludmila, around, ensuring the interpreter has the appropriate language. So many times where people, they've requested for people to come in and do an interpreting job for Aranda language. And there's, Western, Eastern Aranda, Central Aranda language. And, people have invited people to come in and do Luritja interpreting, not specifying, that it's Luritja Punjabi or Southern Luritja, which is a lot like Yankunytjatjara. So that's really interesting as well. And sometimes it's hard trying to get all that information when you brief with the lawyers or the courts people. And before we go out onto these jobs, we need to make sure that we're going into a culturally safe place to make sure that our protocols are aligned as well around poison relationships, to make sure that we're not going in and interpreting for someone that we are not allowed to have contact with, and things like that, or being gender specific as well.
Oh, thanks so much, Lavinia, for this comment. That really illustrates the kind of situations that this standard addresses. Another relevant point here is the existence, the creation of what this document calls language tiers. Language tiers are 4 language groups according to the number of interpreters that are certified and qualified in a particular language. So let's say tier A, so there are tiers A, B, C, and D. So tier A has the a list of languages with the largest number of certified interpreters, and they can be languages such as Mandarin, Spanish, perhaps Arabic, French. Tier B has a lesser number of interpreters who are certified at professional interpreter level. And tiers C and D, as you can see from this slide, have a lesser number of certified interpreters. And these tiers include the majority of Aboriginal and Torres Strait Islander languages. So tier C, for example, has more than 10 CPI, certified professional interpreter level interpreters. And tier D has the languages that have even less than 10 CPI interpreters. Now, what happens if certified interpreters are not available? Then those who employ them would have to turn to recognized practicing interpreters. And if they are not available either, then the judge determines who is what they call a suitable person. So who can be allowed to interpret in court, even if they don't have any NAATI credentials.
So this is important, Ludmilla, really, in just making sure that the courts try and book the best qualified available interpreter.
Absolutely. Yeah. The best qualified available. And if, let's say, the assignment is taking place somewhere in a regionally or remotely where the interpreters with the right language or that are culturally appropriate are not available, that's when the courts will be looking at the next level, at the lower level of a certification or recognition or at a suitable person. Yeah. So we are now looking at support for interpreters, and you will notice that the introduction of this provision contrasts very much with other documents, with other guidelines on working with interpreters, because actually it talks about supporting interpreters. So let's see in what way courts and tribunals should be supporting the interpreters according to these recommended standards. Well, adequate and appropriate working conditions is one. And you would know, those of you who have worked in courts, how often an interpreter does not have a dedicated place and how often it is difficult to hear in a court with poor acoustics. Another point recommended is remuneration. So it is recommended that interpreters are paid according to their qualifications. And what's more, they should be paid for their preparation time and their travel time. And they should be paid for the time contracted, even if a hearing has been cancelled. But as you know, or as you reminded us, Lauren, these recommended standards are not mandated. They are recommended only. And probably, as you know from your experience, quite a few of these recommendations have not as yet been implemented. Interpreters, it is recommended, should be provided with a dedicated waiting space with internet at courtroom. And this is so that the interpreters could consult either electronic dictionaries or some other reference materials, be it on their laptop or using their smartphones if they brought them to court. And another recommendation is to create regular breaks during proceedings. So actually, the recommended national standards do recognize that interpretation is not a mechanical process and that interpreters become fatigued and they need a break every now and then.
That is so important to remember that break, Ludmilla. I know that sometimes when I go from one language to another, that sometimes it can get a little bit too much and too much information that goes in, and those breaks are really important. And I think we as our mob out there, we need to be strong and be able to verbalize when we're getting tired and fatigued, to have a break and, you know, remind the judges and people in the courthouse that, you know, we need a break. And it's so important for that internet, I guess, sometimes during, you know, to be able to, if there's a word that you need to quickly search up, or, you know, if you need to have a brief maybe back with your quick debrief with your line manager or anything like that, you know, I think it's really important to be able to have that opportunity to do that during those times.
Yeah, absolutely. I think it's a very valuable observation based on your practice. And you mentioned switching from one language to another. Of course, one cannot do it just automatically, and one needs time and needs a break and needs to catch up. So we are now turning to the next section. What are the judicial officer's responsibilities? In other words, what can the judges and magistrates do to support interpreters? And let's remember that the judges and the magistrates are the key figures who are the most important in the court in terms of making rules and monitoring how the proceedings are going. So as many interpreters say, the judge is your friend. So according to the recommended standards, the judge and the magistrate, the judicial officers, have to be able to assess the need for an interpreter. In other words, they have to check whether a witness or a party require an interpreter. They have to be trained in not only in assessing the need for an interpreter, which is part of the recommended standards, but they also have to be trained on how to work with interpreters. And that does not come, it does not come intuitively or automatically. It is important to undertake training on how to work with interpreters in accordance with these standards. And I would add here that many judges and magistrates would say something like, well, I've been working for many years and I'm used to working with interpreters, so I don't need the standards. Well, we have to disagree, because the length of experience does not necessarily mean that judicial officers know the best practice of working with interpreter. So let's look at the point proceeding with an interpreter. A judicial officer should check the interpreter's certification, qualifications, and while before the proceedings start, they should introduce the interpreter and explain their role to court, the same as they do with other professions, with the counsel, both for the prosecution and for the defense. Does it always happen? Not necessarily. We know from experience that sometimes an interpreter is not introduced by their name, and more often than not, their role is not adequately explained to the court or to the jury.
It's important to remember this one, I think, too, Ludmilla, so that you as an interpreter can also be prepared if the judge is going to ask you, so what are your qualifications or are you certified? So it's a good little heads up there.
That's right. Thank you. So indeed, to be prepared for that question. It's also recommended that the judges and magistrates ensure that the interpreters are provided with professional working conditions, that they are comfortable. They should ensure that the interpreter has received briefing and be given time to read documents if they are presented, if they are read out in court.
So many
Also,
times where you don't get that briefing prior to the court, and and it's so important that we push that we need that briefing and that time to read the documents.
Absolutely, Lavinia, you're so right. We know that more often than not, interpreters are not given any briefing and any preparation. And if they try to initiate a request for documents, often the lawyers do not react in the most friendly or cooperative manner. And this is why the standards recommend that it's the judge or the magistrate try and ensure that the interpreters have been briefed and provided with preparation material. And hopefully over the years, we will see an improvement in this practice.
We heard a few reports, I remember, during our live session from different interpreters, some who said, yes, they were systematically given the charge and précis to read and that they could refer to it whilst it was being read out and they were interpreting, and some who've like, nope, never seen one, never offered to them. So important to know that if you do want it, the judge has got your back.
That's right. That's right. So if a situation of this kind or if any other problems arise, so the interpreter should alert the judge. The interpreter should address the magistrate or the judge about such a problem. And if an interpreter is familiar with the recommended standard, they can quote it to the judge or magistrate. Now, the judge should also be addressed if the interpreter becomes aware of a conflict of interest. And you gave us some examples, Lavinia, on the previous slide. So the interpreter should speak to the judge and ask to withdraw from the case.
Yeah. And like if our mob are out there in the field working and there is a situation where you're feeling uncomfortable for cultural reasons, culturally unsafe in what's being carried out, or whether it's a bit of a conflict to maybe with your family, because let's face it, we're all from a small community, we all know each other's family, we all know how we're all connected and whatnot. So if it's starting to get to a bit of a sticky point, don't be afraid to speak up and let the judge know.
Yeah, thank you. That's great. And the last bullet point here in this subsection is that it's recommended that the judge or the magistrate should speak at a reasonable speed and with pauses in between sentences. So not to rush, not to speed up, to facilitate the interpreter's task. And using plain English, and that's standard number 14, is also similar to that, to support an interpreter by trying to use plain English, that is to try and avoid complex sentences, very long sentences, break them up. If there are any specialized terms, legal terms, or technical terms that clearly won't have an equivalent in the other language, the judge should provide an explanation in the same way as they provide explanations of complex terms when they address a jury. It is recommended to avoid double negative or other complex grammatical constructions. And it is recommended that they use active voice rather than a passive voice. Something like, do you know XYZ rather than is it known to you? Yeah, so you use active voice and shorter sentences and provide explanations. So this, in a nutshell, this is what the standards recommend for judicial officers to abide by.
Yeah, that's really interesting, the plain English, because I know that I, as an interpreter, would probably draw on that plain English, because sometimes English is so complex and some of the wording can get so complex that there's a risk of misinterpreting what's been said. So it's good
Yes,
that opportunity and option is there.
that's right.
I also wanted to go back to one of your first points that you pointed out around assessing the need for an interpreter and whether a witness or a party requires it. Sometimes the witness may not need the interpreter, but sometimes it might be the party members that needs the interpreter. So it works both ways. It's not always just the one side. It could work both sides, and it's so important to remember that when we go out into our field and do that work.
That's right. And to my knowledge, the judges and the magistrates do not, or the tendency is not to reject a request for an interpreter, even if a defendant or a witness speaks some degree of English. But as you were saying, the court is a very challenging place, and the difficulty of the language used is that it is legal language. A lot of what is said is specialized, and there are no equivalents because legal systems are very different, and Aboriginal law is so different from the Anglo-Australian law. So the concepts are different, the procedures are different, the terminology is different, and it needs to be recognized.
Yeah, absolutely. Yeah.
So we've been talking about the responsibilities of judges and magistrates. So what else should an interpreter be prepared for in court? The judge, or actually sometimes it can be a court officer, the judge could ask your name and ask you to explain what qualifications you have, if you are certified by NATI, if you are an OSIT member, if you are, which language service provider you work for, have you had any training, or even have you had any experience of interpreting in court? And they might also ask you if you understand and will follow the court interpreter's code of conduct, which is part of the recommended standards. And when you interpret evidence, you will be asked to take an interpreter's oath or affirmation. So the interpreter's oath is usually done on the Bible, and an affirmation is what's called a civil affirmation. So it's not a religious statement. So the text that you will hear is something along these lines. Do you swear by Almighty God, or do you affirm that you will faithfully interpret all the evidence and other matters relating to this case to the best of your skills and ability? Say, I do.
I do.
Thank you. So that was a little role play, and this is exactly what happens in court. So be prepared to say, I do. Yeah. So we'll give you a little demo of what can happen in court. Let's say I have an interpreter here, Lavinia Hevenan, and I'm going to say the following. Madam Interpreter, could you please state your name and your qualifications?
Yes, so my name is Lavinia and I am NATI certified in the Luricha language. And I am a member of OSIT as well.
And Madam Interpreter, have you had any experience of interpreting in court, or is that your first time in court?
Yes, I've had experience in interpreting courts, and I've even had a bit of legal training while I was working with the Aboriginal Interpreting Services in Alice Springs.
Thank you, Madam Interpreter. And now we can switch roles.
Yeah, tell us, Ludmilla, how would you cope with that? What would you say?
I would say something like, Your Honor, my name is Ludmilla Stern. I'm a certified interpreter, certified in Russian-English combination by NATI. I'm a member of OZIT, a professional association, and I have a number of years of court interpreting.
Mm. I actually forgot to say Your Honor, so thank you for reminding me.
Yeah. Look, it's good practice. It's good practice when we interpreters address the bench, whether it is a magistrate or a judge, we say Your Honor. And everybody else in court does that. The lawyers, the defendants, the witnesses.
Yes,
Court
absolutely.
Yeah, and of course it's easy if you are NATI certified and you have done training and you're confident with what you're saying. But I guess it's also important to remember it's okay if you aren't those things and the court hasn't been able to find a certified interpreter.
Yeah.
Just speak the truth. They want to understand your situation so they know how best to support you. Because at the end of the day, they're relying on you for justice, right? For everybody to participate in the courtroom.
Absolutely.
That's right. Okay, we are now moving to the next section dedicated to the responsibilities of legal practitioners. And let's remember that a lot of the times it is in criminal cases, it is the prosecution, DPP, Department of Public Prosecutions, that books an interpreter. And according to the recommended standards, it is also the lawyer's responsibility to brief the interpreter. So as you can see, it's recommended that the lawyers brief interpreters in advance and provide all the materials relevant to a case. And that includes the materials that are going to be read out in court, including those that require sight translation. And according to this standard, the lawyers should also give interpreters a reasonable amount of time to read these documents and prepare. Now, let me just pause here for a second and remind everyone that this is what is desirable, but it is not necessarily a standard practice. And many lawyers act surprised when they are asked to provide any preparation or briefing. And you may have either a personal or hearsay experience of that.
Yeah. And again, it comes back to that being culturally safe again, Ludmilla, like making sure that you're not going to do a job for your poison cousin, or you're not going to do a job and it's about, gender specific conversations that you shouldn't be hearing or being involved in the conversation. So you also need to be able to feel culturally safe before you go in, so that you need to ask them that you need this material before you go in, so you don't walk in blind.
Yeah, totally. And I think this is something that needs to be explained to the lawyers, who often say, why do you need to know this? Just interpret, without being aware of these cultural and professional considerations.
And I know that I've gone into a job before where they've, just asked me to come and interpret on the spot, and where I've had to push back and say, well, actually, I need to know the information before I go in. And I remember the lawyer going, oh, I'm bound by confidentiality. I can't share this. And I was able to, well, I didn't know about the recommended standard at the time, but I knew about my OZIT code of ethics and what I about confidentiality, and I was able to lean on that understanding and talk about the impartiality, and me putting it back to the lawyer and saying, I need to be culturally safe before I come in and talk about a subject that I don't know about, and be prepared so I have accuracy when I'm interpreting as well with language that I might not be familiar with.
Yeah, no, this is absolutely correct, and good on you for quoting the Code of Ethics and standing your grounds. The greatest fear by the lawyers, and that comes, of course, from the ignorance about the interpreting process, but their greatest fear is not only confidentiality, but also impartiality. So they fear that somehow the prior knowledge is going to influence the way interpreters will interpret in court, which is clearly not the case at all.
And it's funny because for us, we need to make sure we're going to be impartial before we go into the court case, in case it is a family member, close family member, or distant family member, or with, again, back to that poison relationship again.
Yeah,
Interesting.
yeah, very, yeah. So another subsection is about using plain English, and that's what we already mentioned when we discussed the responsibilities of judicial officers. So use plain English. And the next point, speak at a slower speed with appropriate pauses. It is probably even more relevant to the lawyers than to the judicial officers. The judicial officers don't necessarily speak all that much in court. The ones who speak a lot and speak fast, forgetting about the interpreter, are the lawyers.
I'll have to agree with you on that one. Had that experience as well, where they've gone so fast and you're like, oh, hang on a second. Can you please go back to what you just said and repeat that, please? Because they just so quickly. Even when they're briefing you, sometimes they go really fast as well.
That's right. And, cross-examination, what they call rapid fire, that is a deliberate strategy to be very quick in the barrage of questions that they bombard the defendant with. So, of course, they go very fast. Yeah. Now, documents, not to ask interpreters to sight translate during a hearing. And not, in other words, not to ask them to sight translate a document unseen by the interpreter, especially if it's a complex or technical document. And I understand that Aboriginal and Torres Strait Islander interpreters might have an issue with it. Is that right, Lavinia?
Yeah, well, sometimes, English has a way of wording things that can be misinterpreted and misunderstood or interpreted literally, or and sometimes there's even language and words. I know that I'd be sweating if I saw words that I didn't know how to pronounce or even know what they meant. So, there's also like the eyesight issue as well. So there's so many complexities around having to sight translate, especially unseen documents. And if the language that's used to read uses high technical language, can be challenging and very tricky.
Yeah.
It comes back to that plain English again.
That's right, because these are going to be legal documents that use legal English, often antiquated, that we don't use nowadays. And so it could be a huge challenge. So it's really useful that there is this article here that says, do not ask interpreters to sight translate an unseen document, especially complex or technical. Yeah.
Ludmilla, a question for you, because I've never been asked during court to read something that I haven't seen. If I was asked to read and sight translate a document that I haven't seen, am I able to push it back and ask for a break to be able to have the opportunity to read it?
Definitely, because no matter how simple a document is, one of the practices of sight translation is to first skim read through it, to get an idea what it is about, the content, the vocabulary. And if you feel that it is too challenging, that it is too legal, too technical, you should decline. You should perhaps say something like that. This particular document is very technical and it should be translated rather than site translated on the spot.
Yeah. Okay. Oh, that's interesting to know. And I'm just going back in my mind from what you mentioned earlier, in the previous slides around, you know, having the space to be able to look at documents and use the internet and having that quiet space for yourself. Yeah, so they're all sort of intertwined with each other.
That's right. That's right. So we can go to the next section now, which is about interpreters. So you can say, well, we already have a code of ethics, so why do we need to learn again about interpreters' responsibilities? Well, for a number of reasons. One of the reasons is that a court is a very particular setting, a very particular context. And so these standards are provided for this particular environment. So here we are reminded that the interpreters are the officers of the court. And as the document says, they owe to the court or tribunal paramount duties of accuracy and impartiality in the office, in their role of interpreter, which override any duty that the person may have to any party to the proceedings. So the duty is primarily to the court and not to a party, even if they have employed you directly and if they are paying you. It should not be a consideration. You owe this duty to the court and you remain impartial. Now, the recommended standards include also a code of conduct, which is on the next slide, and we'll talk about it. And it is recommended that the interpreters become familiar with the court interpreters' code of conduct. And then the standard number 20 reiterates that the interpreters have to interpret impartially. So they have to be neutral. They don't have to give preference to any of the parties, or they shouldn't disadvantage them if they have some sort of an antipathy, if they dislike them. They should interpret accurately and completely, as accurately and completely as possible. So don't omit anything. Interpret every conversation. Interpret every aside. For example, if a witness in the witness box wants to speak to you, you have to interpret that too, rather than engage with them in a side conversation. Now,
that can happen quite a bit, can't it? I've seen plenty of witnesses get really frustrated.
Yes.
Like you were talking about before, there's often rapid fire questions and they're really hitting the witness hard. And I've seen witnesses in language get cranky and swear at the lawyers.
Yeah,
and that puts the
that's
interpreter
right.
in an awkward position.
Well, the interpreter should interpret everything, not to provide, in order to provide equal access to the communication. You know, we use the expression to make the defendant linguistically present. And by that we mean that everything that everybody else says should be interpreted for the defendant so that they can follow how their case is going, so that they can ensure their defense. But it also works the other way around. Other participants also are entitled to understand everything. And there should be no asides between a witness and an interpreter. So whatever the witness says should be immediately interpreted into English for the benefit of the court. So going back to that last segment, confidentiality of all the information acquired. You know, we are familiar with it from the Code of Ethics. Now, alert the court of any conflict of interest and withdraw. And Lavinia, this is what you were commenting in, yeah?
Yeah, again, we're seeing brought up here and the importance of, if you're feeling uncomfortable and you realize it's a family member or they're talking about a close family member of yours, or you pull out. Like, don't, like, if you're feeling that, this is a bit of a conflict of interest, let the judges know, let the lawyers know, that's our role and responsibility to make sure that we notify, so we can pull out if we need to.
That's right. That's right. Thank you. So, it's not just an option. I think it's important that it's a duty. That's what the interpreters should do. Now, the last 2 points are interesting. Comply with the directions of the court and tribunal. In other words, a judge or a magistrate may ask the interpreter to do something that might not align with the interpreter's Aussit Code of Ethics, but the directions of the court have the priority over anything else. So it's the judge or a magistrate who is the boss in the court. And because of that, if any problems arise, if you need to ask for repetition, for clarification, for explanation, or if you want to correct a mistake, suddenly you realize that 5 minutes ago you made a mistake. The person to speak to is the judicial officer. And it can be done by either raising your hand, or if you are in the dock, by standing up and saying, Your Honor, etc. Addressing, may I address Your Honor? And I think it's illustrated on the next slide, isn't it? Yes. Here we go. So how to address the judge?
Yeah. So, Your Honor, I am now speaking as an interpreter. May I seek leave to have the last question repeated, please?
So it's in that real third person voice, isn't it? Referring to yourself.
Yes,
as the
that's right. And it signals the switch from the voice of the, let's say, witness and the voice of the interpreter. That allows the court to understand who is speaking. That it's not the witness who is saying, may I do X, Y, Z. Yep.
Yep. So I might say, Your Honor, the interpreter requires repetition.
Yep. So here, Lauren, you spoke about yourself in the third person. The interpreter requires repetition. So that's another possibility. And the last one, Your Honor, the interpreter requires a break. So also a third person, but these are 3 examples of what kind of requests an interpreter might want to make: to seek leave, to ask for a break, and to require a repetition. And here we are looking at the code of conduct for interpreters in legal proceedings. Again, let's remember that here you won't see, well, you're unlikely to see contradictions with the Aussit Code of Ethics, but let's look at how specific this code of conduct is. So first, how to apply this code. This applies to anyone who interprets in court: paid, volunteer, full-time, part-time, freelance. Everybody has to apply this code of conduct. Okay, so what are the duties to the court according to the recommended standards? So interpreters in court are there for the court above all others. So you will remember the expression, the officer of the court. That's what the interpreter is according to this code of conduct. So their duty are above all for the court. They are above other duties. I have to make a little aside here and say that not all the jurisdictions and not all the criminal courts have accepted this role, professional role of the interpreter as being officers of the court. There are some reservations, but we won't go into it here. It's up to the jurisdictions and the courts. Now, another point here is that the judge is the boss of the court. If you need to say something during court, say it to the judge. And we have just practiced that, how to address a judge. The duty to comply with directions. So the interpreters must follow directions from the court staff and judges. So again, the interpreter has to act in accordance with the rules of the institution that is the court. The duty of accuracy, well, this is consistent with the Ausit Code of Ethics and Conduct. Be accurate, and remember, by that we also mean completeness of interpretation. Interpret everything. And in addition to that, no omissions, no unwarranted additions, and no misinterpretation. And if you make a mistake, then let the judge know or correct yourself straight. So, you know, if it is a slip of the tongue, you might correct yourself by saying interpreter's correction, or if it is 5 minutes later or the next day, you have to address the judge.
That's really important to remember that and not be afraid to address the judge. I know that it can be intimidating in there when you know, working with, you know, people like judges and things like that. Don't be afraid, because it's about getting the message across accurately, and it's important that we're accurate in everything that we do.
Yeah, yeah. And, you know, if you feel that you made a mistake because you forgot what a lawyer has just said, or a witness, or because they spoke too fast, or because a word is, you don't know the meaning, you know, again, it is your duty to interrupt and ask for repetition, for clarification, for explanation. You can ask the judge to ask the lawyers to speak more slowly, to slow down, to make pauses. Yeah, and be, you know, if you acknowledge that you are not keeping up with the interpretation, with the speaker, it shows your professionalism. There is no loss of face. There is no embarrassment. On the contrary, it shows your integrity as a professional. The duty of impartiality, again, that resonates with the Ausit Code of Ethics. So the interpreters should interpret without any bias, without showing any likes or dislikes, without showing their attitude towards the speaker. And if you feel that there are reasons for you to feel very strongly, you know, a strong dislike or caution or fear, then don't interpret or simply withdraw. Speak to the judge and ask to withdraw from an assignment. So if you can't be impartial, it's better to let it go and withdraw. And remember also, and that sends us back to the items on accuracy and impartiality, an interpreter is not responsible for what the speakers say. They might use the kind of language that you do not normally use. They might use obscene language, or they might act very angry and express their fury at people. You are not responsible. You must not soften the anger or the expression of the fear. You have to convey exactly the same strength of the emotion as the speaker. And we can move now to competence, the duty of competence. Only do work you have the skills and the language for. So we already spoke about being accidentally booked for the wrong language or the wrong dialect.
Yeah.
Anything here, Lavinia?
Yeah, no, just really important to make sure that when you're getting the briefing at the beginning, that it is from your language group, whether you go further and go, okay, well, which community is this person from? But also when I hear about language, I always think about, the jargon that's used by the legal team as well, and ensuring that we are competent and understand that jargon. And if you don't, that it's okay to say, you know what, I'm not the right person for this skill.
That's right. That's right. And, then you tell the judge that you cannot keep up, or that you don't have the right language, the correct language for the client. Yeah. Okay. And confidentiality, well, I think probably everybody knows about confidentiality from the AUSIT Code of Ethics. So whatever you have learned in the course of your assignment remains confidential. You do not reveal it to anyone. There are two conditions, and they are spelled out in the AUSIT Code of Ethics, not in the recommended standards. First, if the witness or the defendant is in agreement for you to release this information, let's say you work as a team with another interpreter, then with the permission of the client, the speaker, you can share it with another interpreter or another person. Another condition stipulated by AUSIT is if you are mandated by the law to reveal some confidential information that you learned about during a case. But otherwise, you maintain confidentiality. Again, you can debrief with your language service provider. You can debrief with your teammate, with a wider team, but it should remain within those boundaries.
Yeah. And I was just thinking, like, coming from a small community where everybody knows everybody and we're all connected, sometimes it's good to let the person that you're interpreting for know that, you're not going to go and tell other people about what's going to be discussed in this courtroom, that it's going to remain between just us and this space. Because I think there's a little bit of fear that, word will get out by the interpreter, but, we're bound by confidentiality.
Yeah. I remember years ago, I had an experience in court. I was booked to interpret in a shoplifting case. And when I came, I realized, not straight away, after a little while, I realized that I knew the man for whom I was interpreting. And I actually knew his wife, who was in the gallery. I recognized her first. And I still don't know whether the defendant had remembered me from the previous case, but essentially I did not engage with him on a personal level, which one should do in any case. I interpreted, but we did not have any interaction at the end or before, and it wasn't a close connection, but it was just someone I recognized. But I can imagine that this person probably would be wondering whether the word would spread about him being implicated in this case. What would you do, Lavinia, if you were in a situation like this? Would you withdraw, or would you keep interpreting?
I would probably keep interpreting because I know where my boundaries are, and I know that I'm not going to go and disclose the information to other people. And I would probably tell them that I'm not going to go and tell other people that about this case, that it stays in this room. And it comes back to that trust, I suppose, whether you're a trusted person in the community.
That's right. Yeah. No, thank you. Okay.
So thanks for that great overview of the recommended national standards, Ludmilla. There's a lot in there. Anya, what sticks out for you just by way of quick reflection?
I guess, that, be confident. Don't be afraid to speak up and speak to the judge, because, you know, we're responsible for the message that's being conveyed in the courtroom to make sure that it's accurate, and, you know, also around making sure that, you know, we're culturally safe, in a culturally safe environment, that, you know, around that conflict of interest and even impartiality comes into play. And I guess throughout, you know, it sort of repeats it, saying, you know, be impartial, be confidential, be accurate, you know, as you go out and do this work. And for me, being culturally safe also plays a big role when I'm out in the field as well.
Yeah, for me, like, it's clear that there's a lot of repetition and overlap because you're looking at it from the 4 different angles. So you can see that, you know, the judicial officers and the lawyers have a responsibility to speak in plain English, but if they don't, the interpreter has the right and the duty to address that and deal with it. But it's then clear that the judge is the boss. Go to the judge to make sure that everything is as it should be, so everybody can participate and that you can do your job properly as an interpreter, knowing that everyone's there to support you.
Absolutely.
Ludmilla, are we getting it?
Yeah. Oh, you absolutely. You got it beautifully. Yeah, and there is really nothing I can add. I just hope that this document will help to empower interpreters, because in addition to reiterating what the interpreters' duties are, it also very clearly spells out what the duties of the other parties are, of the judge, of the magistrate, of the court officer, of you know, of the lawyer, of the court administration. And that's very important. And as you said, Lauren, just now, you know, the interpreter should not feel intimidated. And if there are any problems, raise your hand, speak to the judge. Your Honor, I, the interpreter, need to address you. And what this document does, it had created a new space for interpreter visibility. A visibility in a sense that the interpreter should not shy away from interrupting the proceedings if the working conditions are not right. And the working conditions include everything. People speak too fast. They are using legalese. They are overlapping. A break is not provided. So that's when the interpreters should remember that it's also their right, but also their obligation to interrupt the proceedings and speak to a magistrate or a judge.
Yeah. Great. So we've been promising a break on this slide here. Thanks for watching this part of the presentation, going through the recommended national standards. In the handout and elsewhere, it's quite easy to find the full document online. Should be able to flash it up here as well. It's available there, all 54 pages of it, if you wanted to find it, and you can use the search function there. Also, as part of this training, we have some scenarios. So we'd encourage you to just take a quick break, but while it's still fresh, come back to these scenarios that are provided in the handout. And in the next recording, we're going to talk through the scenarios and then provide some other legal interpreting resources that are currently available at the end.
And Lauren, can I just jump in and say something else? I forgot to say at the beginning that the first edition of the recommended national standards was published online also in 2017. And just now, recently, a few months ago, a second edition, 2022, has come out. So if you look for this document online, and you'll find it very easily, please make sure that you are looking for the second edition. And the cover that Lauren had shown before is that of the second edition. So that's what it looks like. Second edition, 2022. That's all.
Yeah, thank you.
That one with the pretty...
That's right, with a pattern, yeah. And it says second edition.
Okay, let's go have a break, ladies, and then we'll talk about the scenarios.
Sounds good.